A federal appeals court just triggered a constitutional countdown that nobody saw coming. 3 judges issued an order so unexpected that legal experts are calling it the most dramatic judicial intervention in presidential authority since Watergate. And here's what makes this absolutely extraordinary. The court gave Congress exactly 72 hours to act before unprecedented consequences take effect. Hit that subscribe button right now because you won't want to miss any of the videos I release. On February 9th, 2025 at 4:47 p.m. Eastern Time, the United States Court of Appeals for the District of Columbia Circuit issued an emergency order in consolidated cases challenging executive actions taken in January. The 3-judge panel, in a unanimous decision spanning 47 pages, found that multiple executive orders issued between January 20th and February 1st violated the Administrative Procedure Act, exceeded statutory authority, and in some instances potentially violated constitutional separation of powers principles. But instead of simply blocking those orders immediately, the court did something remarkable. They created a 72-hour window expiring at 4:47 p.m. on February 12th, during which Congress can take legislative action to address the constitutional crisis the court identified. If Congress fails to act within that window, the court's permanent injunction against the executive orders takes effect automatically. Let me explain why constitutional scholars are calling this the most creative and consequential judicial decision in modern American governance. The case began when 17 states, led by California and New York, filed emergency petitions challenging executive orders that fundamentally restructured federal administrative agencies. The orders, signed on January 28th, directed immediate termination of approximately 87,000 federal employees across multiple agencies, including the EPA, Department of Education, and various regulatory bodies. The orders claimed authority under Article 2 of the Constitution and cited the president's inherent power to manage the executive branch. Smash that like button if this is making sense so far. The states argued that mass terminations violated civil service protections, that the restructuring exceeded statutory authority granted by Congress, and that eliminating entire regulatory programs without following proper administrative procedures was unlawful. They sought immediate preliminary injunctions to halt implementation while the underlying legal questions could be fully litigated. The administration countered that the president possesses plenary authority over executive branch personnel and structure. Government lawyers argued that courts have no jurisdiction to second-guess presidential decisions about how to organize federal agencies or which employees to retain. The D.C. Circuit panel heard oral arguments on February 7th in an expedited hearing that lasted nearly 4 hours. According to reporters present in the courtroom, the judges expressed deep skepticism toward the administration's claims of unreviewable executive authority. Judge Patricia Millett, appointed by President Obama, questioned whether the framers intended to create an executive branch that could unilaterally dismantle statutory programs established by Congress. Judge Naomi Rao, appointed by President Trump, pressed government lawyers on how their theory of executive authority could be reconciled with civil service statutes that explicitly limit presidential removal power. Judge Robert Wilkins, also appointed by President Obama, asked whether the administration's position would permit a president to effectively nullify laws passed by Congress simply by refusing to staff the agencies responsible for implementing those laws. The government's responses, according to legal observers, failed to provide satisfactory answers to these fundamental questions. Drop a comment right now if you saw this coming. I read every single one. What happened next stunned the entire legal community. Instead of issuing a traditional preliminary injunction or denying relief, the court created an entirely novel remedy. The opinion, released just 48 hours after oral arguments concluded, found that the executive orders likely violated multiple federal statutes and raised serious constitutional questions. But rather than immediately blocking implementation, the court acknowledged the practical reality that halting mass federal workforce changes already underway would create administrative chaos. So they crafted what they termed a legislative window remedy. The court's reasoning was straightforward but unprecedented. The judges wrote that the underlying dispute reflects a fundamental disagreement between the executive and legislative branches about the scope of presidential authority over administrative agencies. Congress created these agencies through legislation. Congress funded their operations through appropriations. Congress established the regulatory programs they administer through detailed statutory schemes. If the president can unilaterally dismantle all of that without congressional approval, the separation of powers has been fundamentally altered. But here's the brilliant part. The court recognized that this is ultimately a question that should be resolved through the political process, not just judicial decree. So they gave Congress 72 hours to legislatively affirm, modify, or reject the president's restructuring. If Congress passes legislation supporting the executive orders, the court will defer to that democratic resolution. If Congress passes legislation blocking the orders, the court will enforce that congressional will. If Congress fails to act within 72 hours, the court interprets that inaction as an inability to resolve the dispute politically, and the judicial injunction takes effect to preserve the statutory status quo until full litigation can proceed. This framework, the opinion stated, respects separation of powers by giving the political branches first opportunity to resolve their disagreement while ensuring that the judiciary fulfills its constitutional duty to say what the law is if the political process fails. Now things get absolutely wild. The moment that opinion dropped at 4:47 p.m. on February 9th, Capitol Hill erupted into absolute chaos. Senate Majority Leader Chuck Schumer immediately announced that the Senate would hold an emergency session on February 10th to consider legislation blocking the executive orders. House Speaker Mike Johnson countered that the House would vote on legislation affirming the president's authority and condemning judicial overreach. Both chambers suddenly faced the prospect of trying to pass major legislation within 72 hours, an almost impossible time frame given standard legislative procedures. And here's where the political calculations get incredibly complex. For legislation to actually resolve this crisis, it needs to pass both the House and Senate and either be signed by the president or have enough support to override a veto. That's extraordinarily difficult to achieve in 72 hours, even in normal times. In the current environment of deep partisan division, it may be impossible. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Senate Republicans are caught in an impossible bind. If they support legislation affirming the executive orders, they're voting to grant a president sweeping authority to dismantle federal agencies without congressional input. That sets a precedent that could be used by future presidents of either party to effectively nullify laws they dislike simply by refusing to staff or fund their implementation. But if they vote to block the executive orders, they're breaking with a president of their own party and effectively siding with Democratic states and progressive advocacy groups challenging executive authority. Multiple Republican senators have told reporters privately that they're receiving intense pressure from the White House to support affirming legislation while simultaneously hearing from constituents, including many conservatives, who are uncomfortable with the constitutional implications of unchecked executive power over administrative agencies. Senator Mitt Romney, speaking to reporters on February 10th, articulated the dilemma. He stated that while he supports reducing the size and scope of the federal bureaucracy, he cannot support the proposition that a president can unilaterally terminate tens of thousands of federal employees and eliminate entire regulatory programs without congressional authorization. That's not how our system works, Romney said. If we want to reform or eliminate agencies, Congress should do that through legislation, not defer to unilateral executive action. Senator Susan Collins added that she's deeply troubled by the precedent this would set. Today, it's a Republican president restructuring agencies in ways conservatives support, she noted. Tomorrow, it could be a Democratic president doing the same thing in the opposite direction. Do we really want to establish that the president alone decides which laws get enforced and which agencies continue to exist? Collins indicated she would vote against any legislation granting broad executive authority to dismantle statutory programs. Don't go anywhere. The most explosive part is coming next. House Republicans face equally difficult choices, but with different political dynamics. The Republican majority in the House is smaller and more fractured. Speaker Johnson needs near-unanimous Republican support to pass anything, given that Democrats are certain to vote as a unified bloc against affirming the executive orders. But conservative House Republicans, particularly members of the Freedom Caucus, are demanding that leadership bring legislation to the floor supporting the president's actions. Representative Chip Roy told reporters that Republicans campaigned on reducing government bureaucracy and that the president is simply implementing the mandate voters gave him. We should be supporting these executive orders, not questioning them, Roy stated. Representative Matt Gaetz went further, calling the court's 72-hour window an unconstitutional judicial power grab designed to pressure Congress into constraining executive authority. But moderate Republicans from competitive districts are expressing serious reservations. Representative Don Bacon, whose Nebraska district is closely divided politically, said he's not comfortable voting to grant any president unlimited authority over federal agencies regardless of party. Representative Brian Fitzpatrick from Pennsylvania noted that many federal employees in his district are career professionals who have served under both Republican and Democratic administrations and shouldn't be subject to mass termination based purely on political considerations. As of February 11th, at least 9 House Republicans have publicly stated they will not vote for legislation affirming the executive orders. That's enough to sink any bill given the narrow Republican majority. Speaker Johnson is reportedly considering not bringing any legislation to the floor, effectively allowing the 72-hour window to expire without congressional action. That would trigger the court's automatic injunction, but it would allow Republicans to avoid a politically damaging floor vote where members would have to publicly choose between supporting the president and defending constitutional norms. Do me a favor and slam that like button because it genuinely helps this video reach more people. Democrats, meanwhile, are moving aggressively to capitalize on the 72-hour window. Senate Democrats introduced legislation on February 10th that would explicitly prohibit the executive orders from taking effect and require congressional approval for any mass terminations of federal employees or elimination of regulatory programs. The bill, titled the Protecting Federal Workers and Constitutional Governance Act, has support from all 47 Senate Democrats and 3 Republican senators, Romney, Collins, and Lisa Murkowski. That gives Democrats 50 votes, enough to pass the Senate with Vice President Harris breaking a tie. But the legislation faces virtually no chance of passing the Republican-controlled House or being signed into law by the president who issued the executive orders being challenged. House Democrats introduced companion legislation and are demanding that Speaker Johnson allow a floor vote. Minority Leader Hakeem Jeffries stated that every member of Congress should be forced to go on record about whether they believe presidents can unilaterally dismantle federal agencies. This is a fundamental question about the separation of powers and the rule of law, Jeffries said. The American people deserve to know where their representatives stand. But with Republicans controlling the House floor schedule, Democrats have no ability to force a vote against leadership's wishes. Progressive Democrats are calling for use of a discharge petition, a procedural mechanism that allows a majority of House members to force legislation to the floor over leadership objection. But discharge petitions require 218 signatures and take time to gather support. With only 72 hours available, there's simply not enough time to successfully execute that strategy. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. Legal scholars are analyzing the D.C. Circuit's decision and debating whether the 72-hour legislative window is itself constitutional. Some constitutional law professors have praised the court's creativity in crafting a remedy that respects both judicial authority and political branch prerogatives. A Georgetown law professor told news networks that the decision represents judicial restraint at its finest. Rather than immediately imposing their will, the judges are giving the elected branches the first opportunity to resolve a fundamentally political dispute. That shows proper respect for democratic governance while still ensuring that judicial review remains available if the political process fails to protect constitutional and statutory requirements. But other legal experts are questioning whether courts have authority to create conditional remedies that depend on legislative action within specified timeframes. A University of Texas law professor argued that the decision effectively commandeers the legislative process by pressuring Congress to act within an arbitrary 72-hour window. Courts shouldn't be setting deadlines for Congress to legislate, he stated. That's not the judicial role. If the executive orders violate the law, the court should enjoin them immediately. If they don't violate the law, the court should deny relief. Creating a conditional remedy based on congressional response is an improper exercise of judicial power. A former federal judge writing in an op-ed suggested that the D.C. Circuit may have overstepped by creating what amounts to a judicial ultimatum to Congress. While the court's intentions may be laudable, the remedy itself raises separation of powers concerns. The judicial branch decides cases and controversies. It doesn't broker political negotiations or set legislative timelines. Stay with me. What comes next will completely change how you view the situation. The administration's response has been characteristically aggressive and defiant. The White House released a statement on February 9th calling the court's decision outrageous judicial activism. The statement claimed that the D.C. Circuit has no authority to interfere with the president's constitutional duty to manage the executive branch. It announced that the administration would seek emergency relief from the Supreme Court to vacate the 72-hour window and allow the executive orders to proceed without interference. On February 10th, the Solicitor General filed an emergency application with Chief Justice John Roberts requesting that the Supreme Court immediately stay the D.C. Circuit's order. The application argued that the 72-hour legislative window remedy is an unprecedented and unconstitutional intrusion into executive authority. It claimed that creating a conditional injunction dependent on congressional action within a specified timeframe violates separation of powers by effectively forcing the legislature to act on the judiciary's schedule. The application further argued that even if Congress passes legislation within 72 hours, there's no guarantee the president would sign it. Therefore, the entire framework is unworkable and should be rejected. As of February 11th, Chief Justice Roberts has not yet acted on the emergency application. Legal observers note that emergency applications are typically referred to the full court for consideration unless they can be resolved on purely procedural grounds. Given the magnitude of the constitutional issues involved, most experts expect Roberts will refer this to all 9 justices for a decision. But here's the timing problem. The 72-hour window expires at 4:47 p.m. on February 12th. If the Supreme Court doesn't act before that deadline, the D.C. Circuit's injunction takes effect automatically. The court would need to issue a decision by early afternoon on February 12th to prevent that outcome. That gives the justices less than 48 hours from the time the emergency application was filed to review the issues, confer, and reach a decision. Supreme Court experts say emergency decisions on that time frame are possible but rare. The court issued emergency stays within hours during the 2000 Bush versus Gore election dispute. But that case involved an ongoing election with hard deadlines imposed by federal law. This situation, while urgent, doesn't involve the same kind of external deadline pressure. If the Supreme Court chooses not to intervene, it's a devastating signal about the strength of the administration's legal position. When the nation's highest court declines to stay a lower court order that restricts executive authority, it suggests the justices believe the underlying legal claims are weak and the lower court acted appropriately. Conversely, if the Supreme Court grants a stay and vacates the 72-hour window, it would represent a major victory for expansive theories of presidential power and a significant rebuke to the D.C. Circuit's attempt at judicial creativity in resolving separation of powers disputes. If this blows your mind, hit that like button right now. Here's what makes the political situation even more complex. Several Republican senators are reportedly using the 72-hour window as leverage to negotiate with the White House on entirely separate issues. According to sources familiar with closed-door discussions, these senators have told administration officials that their votes on legislation related to the executive orders could depend on White House positions on upcoming budget negotiations, judicial nominations, and policy priorities. Senator John Cornyn, for example, is said to be seeking administration support for border security legislation in exchange for voting to affirm the executive orders. Senator Lindsey Graham is reportedly pressing for commitments on defense spending increases. This kind of legislative horse trading is common in Congress, but the compressed 72-hour time frame makes it particularly fraught. White House officials face pressure to make deals quickly to secure enough Republican support to pass affirming legislation. But making hasty commitments on major policy issues to win short-term legislative victories can create long-term political and substantive problems. Meanwhile, progressive advocacy groups are mounting massive pressure campaigns targeting moderate Republicans. Organizations including the American Civil Liberties Union, Sierra Club, and various labor unions representing federal employees have launched television and digital advertising in competitive congressional districts. The ads feature federal workers describing their careers of public service and asking constituents to urge their representatives to protect civil service protections and vote against legislation that would grant presidents unlimited power to fire government employees for political reasons. A particularly effective ad running in Maine features a 30-year EPA scientist discussing her work protecting water quality and asking why Senator Collins would vote to allow her termination without cause after decades of nonpartisan service. The ad concludes with her stating that she's served Republican and Democratic administrations faithfully, and political loyalty should never replace professional expertise in government service. Keep a close eye on this story because the next 24 hours will determine the outcome. As of the evening of February 11th, here's where things stand. The Senate is scheduled to vote on Democratic legislation blocking the executive orders at 10 a.m. on February 12th. That bill will likely pass with 50 Democratic votes plus Romney, Collins, and Murkowski, with Vice President Harris breaking the tie. But it will die in the House, where Speaker Johnson has announced he will not bring it to the floor for a vote. The House is not currently scheduled to vote on any legislation related to the executive orders. Speaker Johnson is reportedly meeting with the White House to discuss whether to bring Republican-affirming legislation to the floor or simply allow the 72-hour window to expire. If he brings legislation to the floor and it fails due to Republican defections, it's a humiliating defeat for the Speaker and the President. If he doesn't bring legislation to the floor, the court's injunction takes effect, but Republicans avoid a damaging public vote. The Supreme Court has not yet acted on the administration's emergency application for a stay. Chief Justice Roberts could issue a decision as early as the morning of February 12th, or he could refer the matter to the full court, which might not act before the 4:47 p.m. deadline. If the court doesn't intervene, the D.C. Circuit's injunction blocks the executive orders starting at 4:47 p.m. on February 12th. That would require the administration to immediately halt all workforce terminations and agency restructuring pending full litigation on the merits. Approximately 23,000 federal employees have already been terminated under the executive orders. If the injunction takes effect, those employees would likely have legal grounds to seek reinstatement, though the practical mechanics of reversing terminations on that scale would be extraordinarily complex and time-consuming. Before we go any further, smash that subscribe button so you never miss content like this. Here's the constitutional crisis we're facing. Congress is fundamentally deadlocked and cannot pass legislation resolving the dispute within the 72-hour window. The House and Senate are controlled by the same party, yet they cannot agree on a path forward. Even if the Senate passes blocking legislation, it dies in the House. Even if the House were to pass affirming legislation, it would die in the Senate. And even if, by some miracle, identical legislation passed both chambers, there's no guarantee the president would sign it if it limits his executive authority, and there's certainly no time to override a veto within 72 hours. The D.C. Circuit's legislative window remedy, while creative, assumes a functional Congress capable of acting decisively on compressed timelines. That assumption does not match current political reality. This means the 72-hour window will almost certainly expire without congressional resolution, triggering the automatic injunction. The administration will then face a choice: comply with the injunction and halt the executive orders while pursuing appeals, or defy the court order and continue implementing the executive orders in violation of a federal appellate court ruling. That would trigger an immediate constitutional crisis over whether the executive branch must obey judicial orders. Legal historians note that presidential defiance of court orders is extraordinarily rare in American history. Andrew Jackson reportedly said of a Supreme Court decision, "John Marshall has made his decision, now let him enforce it," though the historical accuracy of that quote is disputed. Richard Nixon ultimately complied with the Supreme Court's order to turn over White House tapes despite his initial resistance. Even presidents who disagree vehemently with judicial rulings have generally complied because defiance would fundamentally undermine the rule of law and likely trigger impeachment. But this administration has shown repeatedly that it does not view itself as bound by traditional norms or constraints. Multiple senior officials have told reporters privately that the White House is considering simply ignoring any court order blocking the executive orders. Their legal theory is that courts cannot interfere with the president's inherent Article 2 authority over executive branch management. Therefore, any injunction would be void and need not be obeyed. This is an extreme and dangerous position that essentially rejects judicial review of executive actions. If the president can simply refuse to comply with court orders he disagrees with, the entire structure of constitutional checks and balances collapses. The judiciary becomes advisory rather than co-equal, and presidential power becomes effectively unlimited. Pause for a second and hit that like button if you're finding value in this coverage. Here's where we are right now. 3 federal judges created a 72-hour window for Congress to resolve a fundamental dispute about presidential authority over administrative agencies. That window expires at 4:47 p.m. on February 12, 2025. Congress cannot and will not pass legislation resolving the dispute in time. The Supreme Court has not yet decided whether to intervene and vacate the D.C. Circuit's order. If the court doesn't act, an injunction blocking the executive orders takes effect automatically in less than 24 hours. The administration must then choose between compliance and defiance. If it chooses defiance, we face a constitutional crisis that makes Watergate look tame by comparison. The next 24 hours will determine whether our constitutional system of separated powers and judicial review can function when an executive refuses to accept limits on its authority. The judges made a move no one saw coming. They opened a 72-hour window that they hoped would allow democratic resolution of a constitutional crisis. That window is about to close. And what happens next will define American constitutional government for generations.